So this is the letter from Danielle Sassoon to the Attorney General. She was formerly the U.S. Attorney for the Southern District of New York. It's very interesting. I'm not going to read the whole thing, but it's to Pam Bondi. Um, Dear Attorney General, on February 10th, 2025, I received a memorandum from Acting Attorney General Emil Bove directing me to dismiss the indictment against Eric Adams without prejudice, subject to certain conditions which would require leave of the court. I do not repeat here the evidence against Adams that proves beyond a reasonable doubt that he committed federal crimes. Mr. Bove has rightly never called into question that the case team conducted this investigation with integrity, and the charges against Adams are serious and supported by fact and law. Mr. Bove's memo, however, which directs me to dismiss an indictment returned by a duly constituted grand jury for reasons having nothing to do with the strength of the case, raises serious concerns that render the contemplated dismissal inconsistent with my ability and duty to prosecute federal crimes without fear of favor or to advance good faith arguments before the court. She goes on in here, talks about the principles of federal prosecution. Talks about her background. So she's a real conservative. She clerked with the Honorable J. Harvey Wilkinson III on the U.S. Court of Appeals for the 4th District, and Justice Anton Scalia of the U.S. Supreme Court. And she said they instilled a sense of honor and duty to her for the public good. She goes on to say she can't. Says that I therefore deem it necessary to faithfully discharge of my duties to raise the concerns expressed in this letter with you and to request an opportunity to meet to discuss them further. I cannot fulfill my obligations, effectively lead my office in carrying out the department's priorities, or credibly represent the United States before the courts if I seek to dismiss the Adams case on this record. First section, she says, A, the government does not have a basis to seek dismissal. Talks about Bove's memorandum, identifies two grounds for the dismissal, and says she cannot advance either argument in good faith. The first one, Mr. Bove proposes dismissing the charges against Adams in return for his assistance in enforcing the federal immigration law. He made an analogy to the prisoner exchange in which the United States freed arms dealer Victor Bout for an American prisoner in Russia. So we all know when that happened. And she even goes on to throw some shade at that deal. Let's see what else here. It talks about the judgment. The legal judgment of the Department of Justice must be impartial and insulated from political influence. But talks about Bove arguing against that. Says federal prosecutors may not consider a potential defendant's political associates or activities of belief or beliefs. She quotes a case here, and then Wayne versus United States, and some U.S. code. Let's see. It says the memo from Bove suggests that the issue is merely removing an obstacle to Adams' ability to assist with federal immigration enforcement, but that does not bear scrutiny. Talks about we should reward Adams. Rather than be rewarded, Adams' advocacy should be called for what it is, and an improper offer of immigration enforcement and assistance in exchange for dismissal of this case. She talks about the comparison to the Bout exchange being alarming. The second thing she came up with, Mr. Bove states that the dismissal is warranted because of the conduct of this office's former U.S. attorney Damian Williams, which, according to Mr. Bove's memo, consisted weaponization of the government as defined by the relevant orders of the President and the Department. The generalized concern expressed by Mr. Bove are not a basis to dismiss an indictment returned by a duly constituted grand jury, or at least whereas here the government has no doubt in its evidence or the integrity of the investigation. He talks about the memo acknowledges that the Department of Justice has no concerns about the conduct or integrity of the line prosecutors who investigated the merits of the case and does not question the merits of the case. She also says, I have learned since becoming U.S. Attorney has demonstrated otherwise, that, if anything, I learned that Mr. Williams' role in investigation and oversight of this case was even more minimal than I assumed. The investigation started before Mr. Williams took office. He did not mandate an investigation. The charges in this case were motivated or approved by four experienced career prosecutors, the chiefs of the Southern District of New York, Police Corruption Unit, and career prosecutors at the Public Integrity Section of the Justice Department. Mr. Williams' decision to ratify the recommendation does not taint the charging decision. And notably, Adams not brought a vindictive or selective prosecution, nor would one be successful. She talks about the timing of the cases. Charged in September 2024, 9 months before the June 2025 New York Democratic mayoral primary, and more than a year before the election. Talks about how Adams agreed to all the everything, his legal team, about the trial date. Talks about the she said Mr. Bove's memo also refers to recent public actions by Mr. Williams. It's not my role, she said, it's not my role to defend Mr. Williams' motivation or conduct. Given the appropriate chronology of this investigation and the strength of the case, Mr. Williams' conduct since leaving the government service cannot justify dismissal here. Talks about pretrial publicity. The court has determined that Mr. Williams' statement had not prejudiced the jury pool. The district court has repeatedly explained that there is no evidence that any leak of the media came from the prosecution team, although there is evidence that media leaks came from the defense team, and they have no basis for relief. Mr. Williams, the former U.S. Attorney, his website does not reference the Adams case except for news articles. Then she goes on to make a relevant point here. Moreover, dismissing the case will amplify rather than abate concerns about the weaponization of the department. Despite Mr. Bove's observation that the director to dismiss the case has been reached without assigning the strength of the evidence against Adams. Adams has already seized on the memo to publicly assert that he is innocent, and the accusations against him were unsupported by evidence based only on fair and sensational claims. Confidence in the department would be best restored by means well short of a dismissal. It goes on. Second things, B, Adams' consent will not aid the department's arguments. Mr. Bove specifies that that Adams must consent in writing to dismissal without prejudice. To be sure, in a typical case, the defendant's consent makes it significantly more likely for the courts to grant motions to dismiss under Rule 48A. Cites a case here, United States v. Welburn. Just goes on to make her argument. Talks about the relevant law. And she says, I cannot in good faith request the contemplated dismissal. Okay. Because the law does not support a dismissal and because I am confident that Adams has committed the crimes to which he is charged, I cannot agree to seek a dismissal driven by improper considerations. As Justice Robert Jackson explained, the prosecutor at his best is one of the beneficent forces in our society. When he acts from malice or other base motives, he is one of the worst. Beneficent. She just goes on to explain her reasoning. Talks about, in particular, the rationale given by Mr. Bove in exchange between a criminal defendant and the Department of Justice, akin to the about exchange with Russia, is a bargain with a prosecutor should not make. As explained above, is a bargain a prosecutor should not make. Moreover, dismissing without prejudice and with the express option of again indicting Adams in the future creates obvious ethical problems by implicitly threatening future prosecution of Adams' cooperation with enforcing immigration law provides unsatisfactory to the department. She just goes on. So here's the last couple of paragraphs. I am baffled by the rushed and superficial process by which this decision was reached in seeming collaboration with the Adams Council and without my direct input on the ultimate stated rationales for dismissal. Mr. Bove admonished me to be mindful of my obligation to zealously defend the interests of the United States and to advance good faith arguments on behalf of the administration. I hope you share my view that soliciting and considering the concerns of the U.S. Attorney overseeing the case serves rather than hinders that goal, and that we can find time to meet. In the event you are unwilling to meet or reconsider the directive in light of the problems raised by Mr. Bove's memo, I am prepared to offer my resignation. It has been and continues to be my honor to serve as prosecutor of the Southern District of New York. Very truly yours, Danielle Sassoon, United States Attorney, Southern District of New York. I'm sorry, I can't read really well.